In this video, I would like to talk about the difference between procedure established by law and due process of law. Why are we discussing it here? It is because Article 21 clearly says that no person shall be deprived of his life or personal liberty except according to procedure established by. So, this procedure established by law is very clearly mentioned in Article 21. That is why we are discussing it, part of the Article 21. So, the topic, the heading is procedure established by law and the due process of law. Due process of. So, two different concepts. This can be asked in the main exam, in the preliminary, everywhere it can be asked. And why are we talking about this right now? Because Article 21 says a person or no person shall be deprived of his life or personal liberty except according to the procedure established by law. Except according to the procedure established by law. That means a procedure is already written down by law. The Parliament has already passed a procedure, and you have to, the executive will have to follow the procedure. So, a person's life can be taken away only by following the procedure established by law. The procedure is not an executive procedure, it is Parliament prescribed procedure. That means procedure established by law means Parliament prescribed procedure. Parliament prescribed. Established by law. A law is passed in the Parliament regarding the procedure also, because the constitution makers, especially our forefathers, Nehru and team, they were not very sure about what will the executive do. They wanted to write down even the procedure in the constitution. So, the constitution makers, including Ambedkar and Nehru, they deliberately used the term procedure established by law. They deliberately used this term. It is not an accident. They deliberately used this term so that the procedure will be, they had more faith in the parliamentarians, in the lawmakers. The lawmakers will ensure, will look into all aspects of it, they will study, they will look into, then they will come up with the procedure, and it is the duty of the executive to implement the procedure. So, under this doctrine, the court also, since it is procedure established by law, it's already a lot of debate and discussion has gone through the procedure. The court, the Supreme Court especially, or the High Court, the court will examine the law only from the point of view of the legislature's competence. That means the court has faith that this procedure established by law, reinforce that the court will repose faith in the wisdom of the legislature. Okay. The court will repose faith in the competence of the legislature. In the competence of the legislature. The court will, they will accept, or rather they will buy their argument, the legislature's argument. The court will not question the legislature's competence. The court will not, scrutinize the procedure already prescribed. The meaning is, in procedure established by law, the court will not scrutinize the procedure already prescribed by the legislature. The court will not scrutinize. Why? The court has faith in the competence of the legislature. The court will only look into whether executive has followed the procedure or not. Whether executive has followed the procedure or not. The court will only look into whether the executive has followed the procedure or not. The court will not go behind the motive behind the law, the procedure, because they have faith in the legislature. They will not look into the motive behind the law. Why this procedure is there, they will not look into. So, procedure established by law is a, where judiciary has a lot of faith in the legislature. The judiciary has faith that the legislature will not enact any law, any procedure just like that. But over a period of time, what happened is the parliament started making procedure arbitrarily. The Supreme Court's faith was that but this procedure in a democracy, any procedure should be fair, it should be just, and it should be reasonable, it should be democratic, a fair and just procedure, that's what you always expect. But over a period of time, Supreme Court has found that it is becoming oppressive, fanciful, arbitrary, no logic, nothing, no logic. So, a procedure should be just, fair, logic, logical, or it should be logical, it should be reasonable, it should be fair, it should be just. But unfortunately, our parliamentarians failed over a period of time, and finally in 1978, in the Maneka Gandhi case, Supreme Court declared that just some procedure is not sufficient. Is not sufficient. Just some procedure is not sufficient. It should be just and fair and reasonable and logical. It cannot be fanciful and arbitrary. So, Supreme Court brought the concept of due process of law. Brought the concept due process of law into India, and it's a due process of law, it's a judicial innovation. It is not there in the Constitution. Constitution is procedure established by law. So, we brought in the due process of law. This is an American concept. Due process of law is an American concept, is a concept by the US Supreme Court, US Supreme Court, where the Supreme Court will scrutinize the law. It will look into the procedure. They may even suggest modification. That is why in US Supreme Court, the US Supreme Court is not the third chamber of legislature. US Supreme Court is known as the third chamber of legislature. Why? Because the way the Lok Sabha and Rajya Sabha scrutinizes the procedure, the law word by word, even the Supreme Court will scrutinize the procedure. And Supreme Court even modify and say that this is not acceptable, this is acceptable. So, this can even lead to what we call it as judicial legislation. Meaning judiciary is also making law. Judiciary is modifying the law. See, in India, the original concept is judiciary should look into whether a law is constitutional or not. So, judiciary cannot modify. Judiciary can declare a law unconstitutional, but judiciary cannot make a new law. But why this has happened? This is because the failure of the legislature in coming up with proper procedures. Supreme Court has gone one step ahead and said that we will look into the motives behind the law. We will look into why this law is passed the way it is passed, and they may suggest modification. So, this has given more freedom to judiciary. So, judicial legislation. So, but this is an extreme situation where judiciary is not supposed to make a law, but sometimes what happens is the law which is passed has certain gaps. So, judiciary is trying to fill that gap by suggesting suggesting a particular fill up or filler, by adding something, by modifying something to fill the gap in the law. Okay. So, more freedom to judiciary. This has brought more, and also this is it will broaden the scope, and the judicial review will become more meaningful. So, it will also act as a check and balance, or more powerful checks and balances on the legislature's power to make law. So, the court's power has been expanded, and this will truly ensure this due process of law, will truly ensure the checks and balances in the Constitution, the checks and balances. Meaning, the legislature has the power to make law, but judiciary has the power to declare that law invalid. Checks and balances. So, what is due process? The power of the Supreme Court to even modify a procedure prescribed in a law, or modify a law passed by the Parliament. The power of the judiciary to modify or rectify the defects in a law passed by the Parliament. This is due process of law. And so, this due process of law is also under Article 21 now, because Supreme Court has said that some procedure is not sufficient. Any procedure is not sufficient. This procedure also should pass the test of fairness. It should be just, it should be logical, it should be reasonable. Supreme Court will modify if required, taking a clue from American Supreme Court. So, the power of the judiciary to modify or rectify, or this judicial legislation, the power of the judiciary, or the judiciary taking the responsibility of modifying and I'll say rectifying defects in the law. This is what we call it as due process of law. Procedure established by law, procedure is already written down. Supreme Court will not look into the procedure, it will only look into whether the executive has implemented the procedure properly or not. But in due process of law, Supreme Court will look into even whether this procedure is logical and just or fair or not. So, this is the power of the Supreme Court to rectify, modify a law passed by the Parliament to make it fair, just and reasonable. Most important thing is to make it fair, just and reasonable. This is the meaning of due process of law, or this is the difference between procedure established by law and due process of law under Article 2. So, due process of law is also an inferred right under Article 21 now. That is all about the difference between procedure established by law and due process of law.